Good afternoon, boys and girls. I always want to caution everybody to be very careful of comment section YouTube lawyers. You never know what you're getting. You may get a real lawyer, or you may not. But just because I haven't responded to somebody doesn't mean they're right. And just because somebody keeps arguing doesn't mean that they have a point. This is from a video called Polygraph Test Result. Wow, that was poor grammar on my part. Polygraph test results are inadmissible in Texas. You see what I'm holding up here. In this roughly 15-minute video, I read Leonard v. Texas, PD 0551-10. It's a case out of the Court of Criminal Appeals of Texas, which is the highest criminal court in Texas. The Supreme Court of Texas doesn't hear criminal cases, so you can't appeal to the Texas Supreme Court. You could only appeal if you're a criminal case. You could only appeal to the Criminal Appeals Court of Texas. I read the relevant section of Leonard v. Texas. I even gave you a link right there. It's Leonard v. the State of Texas. It's Leonard v. Texas, PD 0551-10. To give this away, Leonard v. Texas, PD 0551-10. That's this case, PD 0551-10. We're going to take a trip through the mind of a commenter who thinks that they're smarter than a first-year family law attorney. And it turns out, unsurprising, that he's not. So after I read the relevant sections of Leonard v. Texas that hold that it is an abuse of discretion for a trial court to allow polygraph evidence in, doesn't matter if it's part of a probation issue. It doesn't matter if, as part of the probation, you have to pass polygraph tests. Doesn't matter. Polygraph tests are inadmissible, according to Leonard v. Texas. In the state of Texas, polygraph tests are inadmissible in criminal cases, period. They're inadmissible. We can see it. It's stated very clearly in the abuse of discretion. If polygraph test results were inadmissible, then the record would not contain a basis for Strain's decision to discharge the appellant, and the trial court abused its discretion by adjudicating the appellant guilty. And they end up with conclusion. Therefore, only evidence supporting the revocation was inadmissible. So the polygraph evidence was inadmissible. The trial court abused its discretion by adjudicating the appellant guilty. It was an abuse of discretion. The trial court was not allowed to admit that polygraph evidence. He says, so you think a judge cannot admit a lie detector? A judge cannot. Well, in much the same way that you cannot commit rape. Technically you can, but there is a punishment involved. It is not allowed by society. But we're talking about what a judge can or can't do. A judge can't admit polygraph, or it will be subject to being overturned on appeal. A judge can do whatever they want. No, they can't. They are constrained. There is no law that prohibits them admitting into evidence a lie detector test. There is. Leonard v. State. Leonard v. State prohibits them. Romero v. State, which Leonard v. State discusses, prohibits them. Nichols v. State, which Leonard v. State discusses, prohibits them. Every single case, Stockwell v. State, prohibits them. Davis v. State, prohibits them. Every single case prohibits them. Every single case. They are prohibited from admitting polygraph tests, lie detector tests into evidence. And I was an attorney in 2018. I was a lawyer in 2016. I was a lawyer in like 2000, I think. Yeah, 2000. I became a lawyer. So I say they have to follow the rules. They can't do whatever they want. And he says, "Oh, really, Fleabag?" I guess I'm a Fleabag, whatever. I guess you're still wet behind the ears when it comes to what a judge can do. I seem to recall a judge that gave someone a shock treatment. I don't know what he's talking about by that, but okay. I don't know what that is. If that is a allowable thing, I don't know. Like shock probation? I don't know what he's trying to say there. And what about a judge? And what about how a judge can instruct the jury to disregard the evidence as he sees fit? He can't. There are rules of evidence. There are rules of evidence. If something is admitted in violation of the rules of evidence, it's appealable. Hearsay, lack of foundation. There's all these objections you can make to evidence, and a judge can instruct the jury to disregard evidence that was admitted in violation of one of the rules of evidence. Additionally, there are Fourth Amendment concerns, fruit of the poisonous tree doctrine, evidence that is found in violation of the Fourth Amendment, and any subsequent evidence can be excluded from the trial, can be suppressed. And if somebody mentions some of the excluded testimony, then the judge can instruct the jury to disregard that. It's not as he sees fit. There are rules to it. You're just uneducated enough that you don't know what those rules are. California it's called the Evidence Code. It's a whole series of statutes on evidence. What's admissible, what's inadmissible. Damn, moron, learn the law, the whole law, and nothing but the law. Well, I think you need to know more than just the law. I mean, to be a functional adult in society, but what do I know? I'm just a first-year family law attorney. So I asked him, so judges can ignore statutes and rules of procedure? I guess all those appeals are meaningless. When judges ignore the rules of evidence, when judges abuse their discretion, then that's when you appeal it. And that's when the Court of Appeals or the Supreme Court or the Court of Criminal Appeals, whatever the appellate courts are in whatever state you're in, that's when they come along and they say, no, the trial court got it wrong or the trial court got it right. So then he says, hey, moron, in Florida, California, Georgia, and Nevada, polygraph tests can be used if everyone agrees to it, but there are different opinions on the test's accuracy. And then he talks about California, Georgia, and Florida, and that's great. None of those states are Texas. None of those states are Texas. And I want to remind you that we are looking at polygraph test results aren't admissible in Texas. We're talking about Earl. We're talking about Earl taking a polygraph, how he wasted his time. We're talking about Texas. What do those state laws have to do with the topic of Earl in Texas using polygraphs? Did you notice Texas wasn't on that list? He says, just proving a point. We weren't talking about Texas, or we weren't talking about California, Georgia, and Nevada, or Florida. We were talking about Texas. There is no point. I never argued anything about Florida, California, Georgia, or Nevada. I said specifically, polygraph test results are inadmissible in Texas. I don't know what point he's trying to prove. He says judges can use their discretion. They can use it. Absolutely. They can't abuse it. If the judge abuses his discretion, then it's subject to being overturned on appeal. Here is a case that relied on lie detector results to convict a man in Texas. Where did that state come from? I guess. I don't know. Again, judges have discretion. Again, judges can't abuse their discretion. It, in all probability, will not hold up on appeal. It didn't, just FYI. But it can be used, but it can't be abused. Leonard v. Texas. This case said that it's an abuse of discretion. They can't use it. It is an abuse of discretion. Now, in Leonard v. State, the whole reason why the judge allowed it in was based on two reasons. One reason that the judge thought he should allow it in is because one of the terms of this guy's parole was that he showed no deception on any polygraph examination. That was one of his parole terms. So he had community supervision, and he had to show no deception on any polygraph examination. One of the things the trial court said was, I can't make any sense of this unless, because he had this. Part of the thing was that he take these polygraph tests. He got kicked out of the community supervision because he failed polygraph tests. Part of his requirement is to be in this community supervision with this therapist. So I need to have the therapist testify as to why he kicked him out, which means that the therapist has to testify that he didn't pass the polygraph. That was the trial court's thought process on it. That's number one. Number two is expert testimony. Experts can testify, and they could base their opinion on otherwise inadmissible evidence. Those are two things that the trial court was looking at. So the trial court says, we're not actually allowing in these polygraph results, but we're going to allow this expert to testify about the court-ordered polygraph tests and about how he kicked the appellant out of the program because appellant failed 5 of these polygraph tests. That was the court's thought process. The trial court knew that polygraphs were inadmissible, but it didn't know how to get out of that situation. And so the court ended up convicting him. Defendant, appellant, appealed, won at the Court of Appeals. There was another appeal up to the Texas Criminal Court of Appeals, and the Texas Criminal Court of Appeals said, no, you can't do it. You can't use polygraphs at all. So the odds of a judge going and using it again are pretty slim, because this issue has been foreclosed. The judges know what to do now. Now, again, I think, and I haven't researched it, I know that Texas put bills in to create a statute that said if there is court-ordered supervision that requires polygraph examinations, then those polygraph examinations are admissible insofar as they are used in conjunction with the community supervision provisions. I don't know whether that statute became law. I don't know whether the Texas courts followed up on that particular thing, because that's kind of a niche thing, and it doesn't really revolve around Earl and Earl's situation. But as far as Earl's situation is going, the whole point I was reading in the middle, part 4, polygraph evidence, that details the history of the courts of Texas, the history of Texas's dealing with polygraphs. Texas has never allowed polygraphs for criminal proceedings, ever, and still doesn't to this day. So I hope that clears things up. Thanks for watching. Have a great day.